Hey everybody, it's Christopher Small, the owner of CMS Law Firm. We do estate planning, we do probate, we do it well. Today, I want to talk to you about when your estate planning documents stop working, and also, I guess, maybe when they start working. Before I get to that, though, I want to remind you, if you have questions about this or anything else related to estate planning or probate, and you want to talk with us over the phone for free, you can do so by going to cmslawfirm.com. Okay. When do your estate planning documents work? When do they not work? When do they stop working? When do they start working? I get this question a lot. Most of the time, it comes up after someone has died and someone is still trying to use a document that only works when you're alive. Or they're using another document that they think works when you die, but it doesn't work exactly when you die. So let's run through these categories. Medical power of attorney, right? Which is when someone can make medical decisions on your behalf. Clearly, it's around while you're alive. Typically, only comes into play when you lack capacity, when you are incapacitated, and that authority goes away when you die, right? Disposition instructions, which are like burial instructions, only come into play when you are gone, and they are pretty immediate. When you die, that person's in charge that you have named in your disposition instructions is in charge of carrying out your last wishes. Power of attorney only happens, is created when you're alive. It works while you are alive in case you are incapacitated, but it also works if you are not incapacitated, called a durable power of attorney. That power of attorney, though, stops when you die. It only is in play while you are alive. That's when that people get confused often. Someone will die, they've been named power of attorney, they think they get to keep going as a power of attorney, but it's only valid while the person is alive. What else do we have? Healthcare directive, which is pull the plug or not. Obviously, that only applies while you were alive. Will is an interesting one. The will only comes into play when you are dead, after you have died, but the person that you name to be the executor or the personal representative, that's what they're called here, that power does not just automatically come into power. It isn't automatically created when someone dies. What the will does is tell the world who that person wanted to be in charge, but that person is in fact not in charge until a judge grants them letters under a probate saying and telling the world that that person is in charge. So if you are the executor of someone's estate and you have not gotten letters from a court, you are not in charge yet. Okay? No one is technically in charge at that time. And then when it comes to a trust, the trustee of a trust is technically kind of in charge alive and when you're gone, okay? The assets that are in the trust are subject to the trustee's management and authority. Typically, when someone dies, they are no longer the trustee. A new trustee steps in and they have immediate authority to act on behalf of the beneficiaries of the trust according to the instructions inside of the trust. All right, hopefully that made sense. Hopefully you're not acting improperly and without power. If you already have questions, or if you're not and you have questions, you can always reach out to us. If you like this video, though, please hit the like button. If you are someplace that you can subscribe, hit the subscribe button. And if you have questions about this or anything else related to estate planning or probate, and you want to talk with us over the phone for free, you can do so by going to cmslawfirm.com. All right. That's it. As always, I am Christopher Small. I am the owner of CMS Law Firm. We do estate planning. We do probate. We do it well. Thank you for your time. Thank you for your attention. I appreciate you, and I will talk to you again soon. See ya.